agenda, so we will go with that.
I guess the question is, is everybody online?
Yeah. Is everybody online, Joe?
I'm broadcasting, so you can go.
Okay. So, first we'll state that there was no action in executive session. And I will, call this meeting back to order. It's 4 o'clock, approximately 4 o'clock, August 1st, 2017. Megan Lally, Chair of the EQC. This meeting is being held in room 1699 of the Hirschler Building, 122 West 25th Street, Cheyenne, Wyoming. Present today from the council are Tim Flitner, Megan Lally, Nick Agopian, Deb Bomber, and Rich Fair Service. And Dave Bagley. Also present for the council are Jim Ruby, Executive Officer, and Joe Jordan, Council Business Coordinator, and Ryan Jailhouse from the Attorney General's office. I will turn the gavel over to Dr. Bagley at this time as the hearing officer in the Brook matter.
Thank you, Madam Chair. Good afternoon. It's 4 p.m. August 1st, 2017. I am Dr. David Bagley, the hearing officer in docket 17-4802 in regards Brook Mine LLC. This meeting is being held in room 1699 of the Hirschler Building, 122 West 25th Street, Cheyenne, Wyoming. Joining me from the council are Tim Flitner, Megan Lally, Nick Agopian, and Deb Bomber. Council members Fair Service and Degenfelder have recused themselves due to conflicts. Parties present today in person or on the phone are, and I will do as we've done in previous sessions of this hearing, ask for you to identify yourself when I identify your organization. From Brook Mine LLC.
Jeff Pope.
Thank you. From DEQ. Thank you. Powder River Basin Resource Council.
Shannon Anderson is on the
Yeah, they can't talk.
watching, but
They can't talk.
Okay.
so Jill Morrison is here.
Okay, great. Thank you. Bighorn Coal.
Lynn Boomgarden on behalf of Bighorn Coal. Thank you.
And on behalf of the Fishers.
He's online.
Okay. Jay Gilbert's online. The first thing I need to do is handle the motions to strike that we've received. There was a motion, DEQ and Brook moved to strike the PRBRC supplemental expert report. And there was also a motion by the Fishers and PRBRC to strike the DEQ comment to proposed permit conditions and Brook Mine's joinder in the DEQ comments. Having reviewed the record, I find that one, the supplemental expert report should be stricken from the record. The motions of DEQ and Brook are granted. And two, the DEQ comment on proposed permit conditions and Brook Mine joinder should both be stricken from the record. The motions of the Fishers and PRBRC are granted. I would like to remind legal counsel for DEQ, Brook, and PRBRC that the council is authorized under 3511-112A6 to impose sanctions under Rule 11 of Wyoming Rules of Civil Procedure. And some of the order I thought was very clear that went out, and some of the things, all these things being submitted after the fact were just simply inappropriate. At this time, I do not recommend that council impose sanctions, but just to let folks know, please follow the rules as we describe them in the order. Now we'll continue on, and I'm going to ask each council member if they have time to review all the evidence, since not all council members were able to be at all the hearing. Ms. Balmer, have you had sufficient time to review the evidence in this matter?
I have read the transcripts, reviewed all of the evidence.
Thank you. Mr. Flitner, have you had sufficient time to review the evidence in this matter?
Yes.
Chair Lawley, have you had sufficient time to review the evidence in this matter?
Yes.
I know you were there with me, Mr. Gopian, but I'll ask you anyway. Have you had sufficient time to review the evidence in this matter?
Great fortune of spending 10 days with you.
And I also have had sufficient time to review the evidence in this matter. So the council is ready to proceed. Do I have a motion affirming DEQ's decision that the Brook Mine LLC application was complete and suitable for publication and not deficient under 3511 406 H and J?
So move.
Do I have a second? Thank you. So it's been moved and seconded, and what I would like to do is provide, I normally like to go last with my comments, but I'm going to go first since I'm the hearing officer, so I get to pick who gets to speak. And I only have 30 pages of comments. I felt that after 7 days of listening to lawyers that they get a chance to listen to me. No, it's not 30 days. That was supposed to be a joke. Somebody. But let me give my comments on this, and then, of course, I will ask every council member for their thoughts and comments, and then we'll circle back around discussing on the motion. So, discussion on the motion. I will vote against the motion. The reason that I will vote against the motion is that the application has deficiencies. DEQ determination under 406H that the application is suitable for publication was premature. Before I propose a remedy in my comments, I'll briefly summarize my reason. Based on the evidence, I find under 406N that Brook Mine has not met their burden to prove that this mining operation, one, will adequately provide reclamation. I am worried specifically about subsidence. Two, that there will not be material damage to the hydrologic balance outside the permit area. Or three, that alluvial valley floors will not be damaged. But these are 406N considerations, and I can hear the objections already that the council has no authority to consider 406N. That is hogwash. Determining that an application has no deficiencies under 406H when a 406N determination has not been made is a flaw in the administration of the law, clearly within the council's authority, as specified in 3511 112A3. The council shall conduct hearings in any case contesting the administration or enforcement of any law, rule, regulation, standard, or order issued or administered by the department or any division thereof. I could readily show, but I won't, to save you another boring discussion, but I can readily show that unless 406N is considered prior to the 406H determination, a completely illogical outcome of the law could be achieved. To wit, I could show you that the director may have to deny a permit that nobody contested solely because the 406H determination was made prior to the 406N determination. I would also argue that the legislators did not intend for the law to lead to this sort of legal technicality and would expect the administration of the law to be conducted so as to avoid such silliness. Therefore, to avoid illogical outcomes, an application should be considered deficient by definition if the 406N determination has not been made. Now, I'm not going to push further on 406N, but I mention it at this point because it will be part of the remedy I propose. So to clean this up legally, for those who would want to object, I can, based on the evidence, I find under 311 406B that the Brook Mine application has deficiencies in 5 areas. The first area is item 2, plans for surface gradient to a contour suitable for proposed use after reclamation is completed and proposed method of accomplishment. Specifically, the subsidence control plan concludes that there will be no subsidence, but this is based on insufficient analysis of the site. I do not believe that conclusion is merited based on the evidence. Subsidence itself is not forbidden, but how can plans to accomplish a surface gradient contour be developed when the future surface gradient contour does not consider subsidence? The second deficiency is item 6. An estimate of the total cost of reclaiming the affected lands is outlined in the written proposal computed in accordance with established engineering principles. We heard testimony about reclamation cost estimates for the first year of activity. As I read this part of 406B, I see the words total cost of reclaiming affected lands. That, I believe, is missing. The third deficiency, item 13. The procedures proposed to avoid constituting a public nuisance, endangering the public safety, human or animal life, property, wildlife, and plant life in or adjacent to the permit area. And I'll end it there, that quote. In particular, I am concerned with the traffic generated by the mine. I understand that DEQ does not regulate traffic issues, but unless there's evidence of coordination with YDOT and the affected county included in the mine plan, I cannot be convinced that there will not be a public nuisance or risk to public safety from the traffic leaving and entering this facility. Fourth deficiency, item 17. A blasting plan which shall outline the procedures and standards by which the operator of a surface coal mine will meet the provisions of Wyoming Statute 3511-415B11. Here I am concerned that no reasonable limits on blasting schedule have been presented in the mine plan. Without those limits in the plan, blasting could occur at any time or day, and that seems unacceptable to me. And the fifth deficiency is item 18. For surface coal mining operations, a plan to minimize the disturbances to the prevailing hydrologic balance at the mine site and in associated off-site areas, and to the quality and quantity of water in surface and groundwater systems, both during and after mining operations and during reclamation. The evidence DEQ presented has predicted that there will be impacts to wells in the area, in some cases with drawdowns on the order of feet. That is potentially enormous impact for the hydrologic balance in a subsurface as complicated as this one. The plan must include additional detail in those areas identified as having the largest potential impacts. Alluvial valley floors fit into this. Alluvial valley floors depend extensively on the hydrologic balance results, and we see there will be impacts. It was presented in the evidence. More information and planning is needed to address the potential for harm of alluvial valley floors. If you notice a similarity in my 5 deficiencies to my 406N concerns, that is because, in my opinion, the law is logically intended to have 406N completed before a 406H determination is made. It just does not specifically state that. Arguments were made that a complete application is really all that we need to consider. But the contents of the application cannot have deficiencies as defined in 3511-103E14. Arguments have been made that the council should accept the DEQ's determination of no deficiencies and they're suitable for publication determination. The other alternatives they had under 406H were to deny the application or to identify deficiencies themselves. I want to be clear. I highly respect the professionalism and expertise of the DEQ staff. DEQ has done a thorough job reviewing this application. Based on the evidence, though, I disagree with their conclusion that the application was suitable for publication. There are deficiencies, as I have indicated. The evidence indicates, however, that DEQ has not made their 406N determination. I don't know why, and I won't speculate. But DEQ does not have the burden of proof under that anyway. Under 406N, Brook Mine has the burden of proof. Now, a couple other comments before I finally propose my remedy. As I sat through 7 days of testimony on this case, I became more and more irritated by the lack of public input in this application process to date. I cannot find any legal requirements, none were brought forward by the parties, that require more opportunities for public input. So, as far as I can tell, no laws have been broken and everything has been completely legal. But I think common sense has been violated. Many of the concerns raised by the parties could have been readily addressed had Brook Mine held public meetings to provide information and to answer questions during the application process. This would have helped both Brook Mine and DEQ to identify, examine, and potentially address areas of potential concern before a formal suitable for publication determination was made. This would have also helped members of the public learn about a new mining method in Wyoming, as well as learn about issues related to blasting, subsidence, hydrologic balances, the things that we heard about in the evidence. I am not naive. I know that public information meetings may not have resolved all the concerns, and we probably would still have been in a contested case hearing. But I would have had much more confidence that the concerns had been thoroughly examined and evaluated. And also there would be documentation of what Brook Mine and DEQ did specifically to address concerns raised by the public. Brook Mine would have basically built the material necessary to achieve its burden of proof as part of this application process through that. Instead, I found that the process was opaque to the public and evidence is not available at this time to address the deficiencies that I have identified. So finally, now, my proposed remedy. Again, this is just mine, and we'll hear from other council members. One, I recommend that the council members that we vote down the current motion. Two, I would propose that we have a motion that the application has deficiencies under 3511-406H and is returned to DEQ to address the deficiencies. A list of deficiencies will be contained in our order. Three, a new suitable for publication determination can be made after A, Brook Mine has held at least one public information meeting, and B, Brook Mine has addressed the deficiencies to DEQ standards, and C, Brook Mine has addressed comments that arise from public information meetings, and finally D, the administrator has made the necessary 3511-406 in findings. And four, once the new suitable for publication determination under 3511-406H has been made under the conditions noted, the procedures of 3511-406J and K will be followed with formal public notification and opportunity for formal objections. 5, if we end up in another contested case hearing, it will be as short as possible. This will not become an infinite loop. And 6, I think that we, as the council, would tell the director of the DEQ that he need neither issue nor deny the permit within 15 days of receipt of our findings of fact and decision, because we would have found that the suitable for publication determination under 3511-406H was premature, and the deficiencies are still being addressed. So those are my comments, and thank you all for staying awake through those. And I'll now work my way through the council. Councilman Flitter.
Oh, yeah, okay. Well, first of all, I guess I feel somewhat more confident in the way I was thinking. I was worried about missing things when I'm not here in person. I don't like reading transcripts. I think you miss a lot of what's going on. So, but I feel better that I came almost to the exact same conclusion that Presiding Officer Bagley. 3 of those I had identified. One I don't know that I agree with, and the 4th one I just missed, but agree with him today. I also feel strongly about his common sense comment. I feel it's just been absurd that we spent 7 days on this, when really what it comes down to are the issues that Dr. Bagley has verbalized, all of which are very solvable. if people would have just been talking to each other. And it's not like you didn't have time, even after this process started. I voiced concerns about the alluvial water early on, first day of the hearing. Some of the other things, we knew these were issues. They should have been worked on. I just feel like from the very beginning that this thing was headed down paths that could have been avoided. And I think that the DEQ has a little bigger responsibility making sure that we don't come to a 7-day hearing. I realize you had your reasons for doing what you do, and I don't always understand those. But I think maybe you should try a little harder. And I'll use the example of the what are we going to have, the optional informal conference. You know, who knows? Maybe you could have cut this hearing down by a couple of days by having that conference. Maybe there could have been some information that was brought to light there that could have helped solve some of these problems later. Because I didn't see this as being a problem that was all that far apart. And it looks really solvable, and I think Dr. Bagley's pointed that out. So I guess I'm in complete concurrence. I'm going to vote against it, and I agree with almost everything that you said. Matter of fact, it didn't leave much left to say. So I appreciate the time you spent on it. You all have been thorough, and I appreciate it as one who has missed a lot of this hearing. I appreciate that. So that's all I've got.
Councilman Brook.
At this point, I'm inclined to vote in favor of the motion. The permit is complete. There's no time to hear from the DEQ that they have made the determinations on their end. So I don't have any reason to believe that that's before us. We haven't seen where they held themselves out that end was there. I believe that is something that the DEQ, either the administrator or the director, prior to approving the permit, the decision has only been made that it's complete. I find, based on what was presented by the permit applicant and the DEQ, that the permit was complete. While I too share with you your feelings about some of these things maybe could have been resolved, I don't know that they would have been. It's disappointing, extremely disappointing, that the permit applicant has shown no record of public engagement for a mine site located at the base of the Bighorn Mountains within close proximity to many homes. Very disappointing to see that. But at no time did I hear or see anything in the statute or rules that required it. And so I certainly believe that would be well outside this council's purview in the jurisdiction of the DEQ to require that. Something that's not in the rules and something that's not in the statute. But again, I'm disappointed that it didn't occur. I think that it certainly answers a lot of questions. Doing business in Wyoming requires you to be a good neighbor. And this would have been the most simple way to show the community where a large scale mine is going in that they are a good neighbor. So it's disappointing us. And so with that, I am inclined to move the permit forward to the administrator for decision on the merits.
Thank you. Chair Lawley.
First, I'm going to echo what everybody else says. The public comment on this was very lacking. Several of the members of the public that came and testified in front of the council said they weren't opposed to the mine. They just nobody had told them anything, and they were opposed to not knowing. Many of them were miners themselves. So, the lack of opportunity for the public to comment on this is troubling. And I think maybe there needs to be a look at why that was able to happen. So into the meat of my comments. I have a few concerns. One is something that struck me is the new mining technique was supposed to limit the amount of blasting. That was part of what why they wanted to do it that way. And then Brook said that they were going to go ahead and publish that they could blast anytime they wanted. Seems to me, being a good neighbor, there needs to be restrictions on, notice. That's why it was in the law, it says you need to have 30 days written notice for blasting. And then all of a sudden they're saying, you know, this isn't the Powder River Basin. This is Bighorn Basin. It has a different method of mining. You need to have a different method of blasting. And then another concern I have is the ability, if Gramaco does damage water wells, for them to possibly provide water long-term to these properties based on their corporate structure. Because they've utilized a method that oil and gas has used for a long time, oil and gas and coal, to have subsidiary companies run the actual operations. That means that if they decide to close the mine, there's no remedy for those people to continue to get water. And then also, lack of access does not excuse lack of data. There was some concern about, because they didn't have access to a portion of property, they couldn't get data. We issued an order in lieu of consent. Because of that, that data needs to be gathered before the application is complete. However, using the legal argument that lack of information makes the thing incomplete and then denying access is sort of difficult. So under those circumstances, which is B and not N, I will vote that it is not complete. However, I do think that the council does have the ability to consider N based on the fact that this is the last chance for the public to have any input at all in the application.
Thank you. Councilmember Balmer.
Thank you. Well, I wrote up 8 pages of notes. And like Dr. Bagley, I won't bore you with all of them, but I also intend to vote against this motion. I think there are deficiencies in this application, and I just feel like I can't in good faith approve this mine without hydrologic assessment, without that information. We don't have any of that evidence, and nobody gets to comment on that evidence if we exclude N. And I don't think that's the way this thing is supposed to go. I think N applies. I think we have solid case law that tells us it applies in the Graham's case. And I think we need to apply it, and it's not there. Graham's is controlling and directly on point, if you ask me. I was bothered by the technically adequate standard that was argued that this council should apply. And I don't find those words anywhere in any part of the statutes. And so I don't think that's our standard, that it's technically adequate. It needs to be complete, and it's not. Without the N assessments, it's not complete. And I agree with you, Dr. Bagley, with what you stated on the record as the deficiencies. I have written those deficiencies as well. And I think they're deficiencies, they're not minor, and they're not something that we can condition. They need to be completed. I don't think they're subject to conditions. So for those reasons, I intend to vote against the motion. Thank you.
Any other comments from council members? So we will take a roll call vote and remind you the motion is to affirm DEQ's decision that the Brook Mine LLC application was complete and suitable for publication and not deficient under 3511-406H and J. Councilman Flitner.
Yes.
Chair Lawley.
No.
Councilman Gopian.
Aye.
Councilmember Palmer?
No.
I vote no as well. So that motion has failed. So I would like another motion so we can finish this up. And anyone have a motion out there?
Was it a motion to dismiss? Because I don't know what this is.
Can we use your language?
If you'd like to, use what I've written.
All right, I'll throw it out there. I move that the council deny the vote against the application because it has deficiencies under 3511-406H and should be returned to DEQ to address the deficiencies. A list of deficiencies will be contained in our order. A new suitable for publication determination can be made after A, Brook Mine has held at least one public information meeting, and B, Brook Mine has addressed the deficiencies to DEQ standards, and C, Brook Mine has addressed comments that arise from the public meetings, and D, the administrator has made the necessary 3511-406N findings. Once the new suitable for publication determination under 3511-406H has been made under the conditions noted, the procedures of 3511-406J and K will be followed with formal public notification and opportunity for formal objections. If there is another contested case hearing, it will be as short as possible. We don't need to put that in there,
No,
but
I agree.
and I'll leave out, this is not an infinite loop. So none of that. The director need neither issue nor deny the permit within 15 days of receipt of our findings of fact and decision, because we have found that the quote suitable for publication determination under 3511-406H was premature and that deficiencies still need to be addressed.
Is there
That
a
was a long
second?
one.
Could you repeat that? I'll second it.
All right, so now we'll have discussion on that. Go ahead, start with you, Councilman Gokin.
I guess I'm confused. Motion to approve failed. I'm confused as to what action they are voting down. The completeness. Already determined.
I feel like what we need to do is actually have them resubmit with consideration of the deficiencies that the majority have found. No, not to us, but under J, is it? H. I feel like with the deficiencies, if the deficiencies are addressed,
So I guess,
The permit
so
may
my
be
comments,
issued.
I guess, I'll leave it here. I've already identified my belief in whether deficiencies exist, and I don't believe it's appropriate that council at this point add, while I think that it would be very valuable, don't get me wrong, very valuable to have a proactive stakeholder in the town of Rancho. I think it would be. I don't think that's appropriate for us to require that now outside the statute.
Thank you.
I'm wondering if we have authority.
Well, motion can have amendments. Councilman Footner.
Yeah, I do agree with Nick on that point. I think that, there was plenty of time for people to comment. Nobody kept them away. They all had that opportunity. You know, like you say, and I agree with you earlier, the law was followed. Maybe some people didn't act on it. So to require that public comment, I think might be a bit of an overreach. I was wondering if there was a way, instead of specifically putting the things we want in the motion, would it be better to just remand this back to the DEQ with recommendations that are separate from the motion? And that way they know what it's going to take to get it past us, but we haven't limited them to, or ourselves, I guess, as well, to those precise motions, because these things have a tendency to morph a little bit. And I don't want that to come back and say, well, you said if this was all taken care of, this was a done deal. And we hope that to be the case, but you can't guarantee it. So maybe a recommendation would give them the latitude to address other problems as they come up, and not just those specifically. And or maybe those, you know, for some reason, maybe some of those would go away or whatever, but it would allow some flexibility. So just the motion to remand it, accompanied by our recommendations that were listed. Is there a way maybe to do that?
Yeah, I think we could vote down this motion and then propose that.
If
Because
you're agreeing to
that's
it.
more than just amending something out. It's like basically, so yeah, that's how we could proceed. We could vote this down and bring forward.
Because, I guess to clarify, I've always felt like on a practical basis, this is a good project, or could be. And early on, I think there was a lot of sentiment that this was something new and people kind of got excited about. And so, you know, nobody's excited about putting the skids to a project that this is how sometimes things are learned. And this process looked like a good one, but there were misgivings early on, and they never really had been addressed to our satisfaction. And I guess that's really what we want to do, is give you an avenue to get where you need to get, because you didn't get there by yourselves. And and we're all part of it now, and we're hanging our names and integrity on it as well. So now we're your partners too, but we have things we'd like to get accomplished as well. And one of these is getting this done.
So I've been informed that parliamentarily, we could, if the seconder and the motion are both withdraw, then we don't vote on it. Motion goes forward.
I'll withdraw the motion.
All
I
right.
agree
I'll
with
withdraw
what
the second.
Second, okay, all right. So that motion has been withdrawn by both the seconder and the mover. Do I have another? Well,
Come on,
Yeah.
no, so let me provide the answer to Councilman Legopian's question. We have denied this, but we haven't given anybody any guidance as where it should go. And so I believe a motion is necessary. And I think you're on the right track, Tim, where we say, now this is what needs to happen next, but give it as broad a view as possible. I think it's what you were saying.
Right.
So we need to say, though, I think, okay, send it back to DEQ with the deficiencies that we will list, and continue the 406H determination. I think that's something like that.
In order.
Yeah.
Okay.
So do you have a sample?
I would make the motion to remand it back to the DEQ with direction as outlined in an order. Would that work? And then we can put your what was part of your motion in the order.
We'll still have the ability to vote. I guess we have. I'll
Yeah.
second.
All right, thank you. Okay, so that's, we now have a motion that will send it back to DEQ for their examination, and we'll have things in the motion written in the order, which of course has to also be approved. So,
So I'm clear
Discussion,
about
go ahead.
That's all I want to be clear about. We just proved we're moving a motion to remand with direction at this point. We have guidance based on your comments.
right, we would have to,
Sufficient,
right.
but as members, we still have the right to vote against what those deficiencies might be. once they've been articulated.
Do we have to do that right now, or can we articulate those on paper and then have a vote on that?
You'll have a vote to approve the order.
Yeah.
And
Okay.
so you can certainly, as that, because that order will go out to you before, and certainly all of you can say, I want this, I want that, I don't want this, I don't want that. Just as you would in any other kind of negotiations on what your order would say. And then at some point, we will reach a vote on the order,
Mhm.
and it will be approved in some form and then sent out to the party.
Do we hash that out now?
No, I know what I'm hearing is we don't have to hash that out.
So
Do
there
we
will
want
be,
to hash that out now?
who is going to put the list of deficiencies together? We're not going to talk about it now.
I was under the understanding that those were, that's
Okay.
pretty much it. I mean, I agree with Nick on the, maybe we could take that one out.
Mhm.
And I think we could hash this thing out in 15 minutes and then they'd have their direction right now today if you guys are not opposed to that.
I think that's reasonable.
Sure, that works
I'm
for
okay
me.
with that too.
We have a motion on the
So
floor.
is the motion to deny the permit due to deficiencies that we articulate and remand to DEQ to consider the deficiencies and proceed under section H? Is that kind of what we're
No,
doing
I
here?
don't.
What is it?
I don't think we use the word deny the permit.
Okay,
The motion said remand, at least that's what I
Remand.
said. I don't know if there's a
yes.
huge technical difference. But
So the permit isn't
Aye.
denied, it's remanded
To correct.
to correct deficiencies.
Yeah, none of us are denying
No,
that there might need to be a mine. We're just
Yeah.
denying It's ready.
I wasn't paying close enough attention to how you started that.
Really?
You started it with the word remain.
I might have changed a time or two.
So one of the motions we have right now is general, but it does provide us the flexibility to make sure that what's in the order the council is happy about, and we don't happen to miss something. And we will get a chance to all look at the order. So I might suggest if we approve that order, if the approve that motion, if the council wants to discuss potential deficiencies that might be included in that order, but not not make a formal motion about that, then that information is we've captured it. We can do some of that discussion now, which is always best done in public anyway. Plus, the people who have to help us write the order will have some ideas, but that doesn't. If we put that into a motion, then we lock ourselves in, and I think that's what you were trying to avoid in the first place.
Right. Yeah.
So if we approve the motion, then we discuss potential deficiencies, argue about them, whatever, for a while, and then, but not make a motion. That may give us the best opportunity going forward.
And then Nick's question, I believe, was if we issue an order, can he vote against it because he didn't agree with the original idea behind the order?
Yeah,
Oh,
it has
absolutely.
the same
I
muster.
wouldn't want to presume how I would vote.
Right, no, but that was my understanding of your question.
That'll be a separate.
I'm not
vote, as I
presuming
understand
you're
I
it.
gonna vote
appreciate,
against it?
no, I know. But, yeah, we can move. I can do the motion. Vote.
Yeah. Any other discussion on that motion? I think it's a good motion, and it then allows us to discuss some general deficiencies, but not, and then what the order will handle separately. So, All right, got to do a roll call vote. I'll call that. Councilman Flitner.
Aye.
Chair Lawley.
Aye.
Councilmember Balmer.
Aye.
Councilmember Ragopian.
No.
I vote aye as well. So that motion has been passed. What we'll do then, the last little bit here, I'm going to open it up for council discussion. To perhaps suggest some ideas of what you may have considered a deficiency. We will not be voting on those and adding those into a motion, but just to discuss those. If someone brought up an idea that you thought was bad, say so, or if you have another one you want to add, but just to get some ideas. We're trying to do that one at a time, but we won't have a motion. So I'll go ahead and start with Councilman Cook.
Maybe it would be helpful if you read those, because, I mean, I can't think of every one of them off the top of my head, but I remember hearing them read, that I agreed with most of them. And maybe we could peel out the ones that there's some disagreement on first and take the rest of them and put them aside, the ones that we all agree on. And then at least everybody kind of have a starting point.
The list.
Because most of those, I think, as I remember hearing them read, were kind of right along the lines that I was thinking before this thing started.
Sure, I'll give you the briefer version. A deficiency. I felt there was a deficiency in the plans for the surface gradient because of the subsidence control plan, simply assuming no subsidence. So I didn't feel you could claim something if you didn't know what it was going to look like.
We talk about each one of these as you're.
Sure, yeah, so there's.
So I don't have to remember them all.
Yeah.
I had written down subsidence control plan was not. And so I agreed with it, just more generally, the subsidence control plan was deficient.
Agreed.
I agree that they didn't address it properly, but I'm not sure how they can decide what's subsidence related to mine and what's continuing subsidence related to other. Because if you look at the landscape around there, it's pretty subsided anyway. And so I'm not sure how they can address that, but saying that there's not going to be any subsidence is probably not the proper way to do it.
Right. I've thought about this from a engineering standpoint. And I think I don't think that the subsidence control plan for the entire site needs to be done today. But I would like to, there was not enough data collected on the initial site where you're going to start first.
On the TR1.
Yeah, and they said it would be in the ground control plan, and that's fine, except the ground control plan does not specifically address long-term subsidence. It addresses collapsing on the people doing the mining at that time.
Right.
And so, and I'm just spitballing, and people could, I don't know how we would include it, and we may not include it with this kind of detail, but because if it goes back, DEQ will have to decide. But I would think that some additional data related to where they want first to go and showing, and the additional data may confirm that they really don't expect subsidence. It just wasn't enough data, I did think. And then if they could show for that, as say the first part before they move on.
I had written down that more sampling should be done in the TR1 area. And it may confirm what they suspect is there, but I don't think the sampling was sufficient in the TR1 area.
Well, I think the point is we don't need to tell them what to do. That's their job. We need to tell them, these are where we have the questions.
Yeah.
One of the issues that we are unsure about is subsidence control. Bring us some information and convince us. That's what we're saying. We're not giving them direction on how to fix it.
Yeah.
We're saying, show us you've made an attempt to address it.
Right. Any other questions or thoughts on that one? Any thoughts, Nick, or should we just jump in when you're ready, which is perfectly fine?
You know, I don't have any comments. I thought mine's intended not to subside. And there's every indication that the Brook mine would be responsible if subsidence were to occur. So I don't foresee any issues.
Okay. So the second one I had was that an estimate of the total cost of reclamation was not presented. We heard testimony about the reclamation cost estimates for the first year, but not for the total cost of reclaiming the affected lands. But again, I felt that was a deficiency. That's just me. Is there any discussion on that?
I'm in the middle on that. I mean, I can go either way, so no comment from me.
Yeah.
I sort of felt like DEQ would handle that, but
Yeah, as long as they bond on the disturbed lands.
yeah.
Okay.
That's really my only
And
concern.
And I feel like that's in the permit, that they have every intention of making sure that that is okay, but I'm in the middle on it as well. It's not a deal breaker for me, so.
Yeah, so what I'm hearing is that folks don't really consider that a major deficiency because it's going to be covered by bonding and things anyway. Okay, and that's fair. I'll cross that one out. The third one was I was concerned about procedures proposed to avoid constituting a public nuisance and endangering public safety. And I was specifically worried about the traffic generated by the mine and whether there was evidence. I know that DEQ doesn't regulate that, but any evidence that coordination with YDOT and the county have begun on that issue.
And somebody else would issue road permits and things, correct? I mean, the county would have to be involved in all of that. Is that outside of our?
I think so.
That was the only one that of the five that I that I was telling you I disagreed with. I think that, again, I mean, hopefully the mine plan will take care of a lot of that. And that's where I am on that one.
Yes, I guess my point was I didn't feel the mine plan had taken care of that. And as a public nuisance, which we saw this a couple of years ago with the gravel pit, to be honest. I mean, but your comment's still totally valid. Just arguing with you for fun.
Yeah, I don't find any, that's outside of the purview of this, I think. This, I think. That's what I said.
Nick?
Oh, no comments.
All right, so there wasn't a real agreement on that one either. I'll go ahead and throw that one out. Blasting plan, which shall outline the procedures and standards, and I was concerned specifically about limits on a blasting schedule that have basically the plan is written is that they would blast. They have the ability to blast at any time, any day or any time of day.
And I totally agree with that one. I don't know that this comment or this council's ever been in the habit of issuing permits that don't have those kinds of things in there. I mean, even gravel crushing have to have operational hours. I think that is one of the things that the DEQ just missed. I mean, that's a red flag that they weren't paying very close attention. Got to have those things.
I think in light of all the homeowners that are so close, then it just is necessary.
I've already made my comments on that.
Okay.
I think there need to be limits based on when they're actually blasting.
Nick?
Thought that the Brook mine presented some valid reasons as to why they would like the discretion to blast as appropriate. There's no evidence to suggest that they were going to do so in a way that intentionally sought to harm any of the landowners.
Okay. Thank you. And the fifth one was related to disturbances of the prevailing hydrologic balance at the mine site and in associated offsite areas to the quality and quantity of water and surface and groundwater systems, both during and after mining operations and during reclamation. And my concern there was there's already prediction that there will be impacts to wells, the alluvial valley floors fit into this because they're part of the hydrologic balance.
I agree. I think that's a difficult one, and I don't think you can really, if you're gonna err on the side of maybe just a little more data. I do appreciate the fact that they relied heavily on 23 years of data from the old mine, and I think that needs to be said. I mean, I want to give them credit for that. I don't want them to think that we're just, well, you just didn't do anything. That's not true. They researched it pretty well, but I think there needs to be some more recent stuff, just something to make us a little more comfortable on
Um, based on the data, there's not going to be significant impacts in terms of water amounts. However, another drought comes and somebody's well goes dry, that leaves them in a bad situation after 5 feet of drawdown or 100 feet of drawdown or whatever. My biggest concern is that they have a way to remedy that lasts beyond the life of the mine. Because those people don't have a well after that. And there has to be a way for that to be funded. And with a company that only has $250,000 in assets, where does that leave the homeowners at the end of the day?
I wrote just generally that the hydrologic assessment was deficient. And I wrote that because of the TR1 area, but I don't think we need to, I agree with Tim that we don't need to be saying you have to do something in this little portion, but not anywhere else. I just felt like it was deficient. The assessment wasn't done in certain areas, and I felt like it needed to be.
Councilman?
I don't have any comments.
Okay. Those were the 5 I identified, and through this discussion, I went ahead and taken out the total cost and the public nuisance ones, not the other 3. Are there any others that folks want to bring forward for discussion?
I think some of the things that I had concerns about weren't really deficiencies. They were just conditions that I would put on it. Like if homeowners within a half a mile wanted seismic monitoring, it would be provided that. And
I think that's
pre-blast surveys. But I don't think those are deficiencies. I think those are more conditions that I would have added had the permit been granted.
Any other?
No, I think my only other one is lack of data, which goes back to all the other pieces. So.
Well, thank you very much for those comments. We've already passed our motion. So the council will prepare its findings of facts, conclusions of law, and order for approval within the statutory 60 days from the close of this hearing. And I hereby now close the hearing at this time. Madam Chair, I return the gavel to you.
Thank you, Dr. Bagley. I think we will take a 5-minute break, and then when we return, we will go into executive session for personnel. So we'll need a motion when we get back in a few minutes so that the council can assemble and everybody can take care of personal needs.
I need, I'll call this meeting back to order, and I need a motion to go into executive session concerning personnel matters.
So moved. Second.
All those in favor?
Who moved it?
Nick.
Nick. Oh, you take it. You're the secretary. You take minutes. Excellent. Yeah.
Okay.
You
It
just
is,
need a vote.
all those in favor?
Aye.
Opposed? Motion passes. Okay. If you and Joe would step out, please. Everything's for sure off, Joe.
As long as he's only sending it to the Russians.